Good afternoon. I am Jennifer Walker Gates with Walker Gates Vela Immigration Attorneys in Austin, Texas. And I'm here today with Naveen Flores Dixit, who is our San Antonio associate. Hey, Naveen.
Hi.
And we're here to talk today about an important development in asylum law, and specifically with respect to the one-year deadline for filing an asylum application. Under asylum law, there is a deadline that's written into the statute, directly into the code of laws that Congress wrote about filing asylum, and it gives people 1 year after they come into the United States to submit an I-589 application for asylum if that's what they're going to do. So this 1 year deadline is also very, very rigid. There are very few exceptions to it, and it's hard to get around. So for that reason, this is really important for people who are applying for asylum to know and to be able to comply with that 1 year deadline. So Naveen, can you tell us why the 1 year deadline has been so problematic for so many asylum applicants during the past several years?
Yes, I think the main reason why it's been problematic is because people don't know about it. People aren't aware that once you enter the country, there's a clock starts ticking on your ability to apply for asylum, and you only have a year. And if you're unable to file within a year, you can still get a similar type of relief called withholding of removal, but it's more difficult to get than asylum. And it has less benefits than asylum. So asylum is always the goal.
Yeah. And so what is the name of the new court ruling that is giving us, additional opportunities now?
It's called Mendes Rojas v. Chad Wolf.
Okay. And under Mendez Rojas, what is the new information that people need about that 1 year deadline for asylum?
Basically, if you have entered the United States and upon entering you were stopped by immigration officials and you received what's called a credible fear interview, and if you pass that credible fear interview but you were not told about the 1 year deadline, you could qualify for an essentially an exception or forgiveness for that because DHS did not warn you. And the same applies to people who were stopped and received what's called a notice to appear, the document that starts removable proceedings, even if they did not receive a credible fear interview and were not told about the 1 year deadline by immigration officials.
Okay. So for anyone who has come into the United States and had an encounter with immigration authorities who then put them into immigration court proceedings, those people are able to get an exception to the 1 year deadline now under this new ruling. Is my understanding correct?
Yes, it is.
Okay. And according to Mendez Rojas, how is it that people are supposed to get that exception? How are they supposed to take advantage of that?
Well, people can raise a claim if they're making a new filing in their new asylum filing with their application, or if they're already in immigration court, they can, through their attorney, write a motion. But if they don't have an attorney, they can try to send a letter to the immigration court where their case is, and to the Department of Homeland Security, who is the counsel or the attorneys for the government.
Okay. And what is there a deadline for people to be able to take advantage of this new decision?
Yes, the deadline is April 22nd, 2022.
Okay. So a little more than a year from now, people need to have submitted either their application for asylum by that time, and or a request that the 1 year deadline not be applied to them because of this court decision. Is my understanding correct?
That's exactly right, yes.
All right. So that is huge. huge information for so many individuals. And my hope is that, you know, anyone who doesn't have an attorney to raise this issue for them either knows to do it for themselves or, you know, has a judge and or government attorney in their case who, you know, fairly and appropriately applies this decision in their case. The purpose of us making this video today is to let as many people know in our audience as possible, like if you have an application for asylum or you intend to apply for asylum, that April 22nd, 2022 date is a huge one for you. You need to make sure that if you did not file your application within 1 year of your entry to the United States, that you take advantage of this decision to get a little bit more leniency in your case, because that 1 year deadline can make a huge difference in your ability to win asylum and therefore be able to reunite with your family, ideally, and proceed in the United States toward full lawful permanent resident status and citizenship. So with that, we will sign off for now. Stay tuned to our YouTube channel, subscribe. We'll be posting more updates and information about this case, as well as resources for people to use to be able to understand how to effectively file their applications and file a request under Mendez-Rojas for an exception to the 1 year deadline. So Naveen, thank you so much for joining me, and I will see you in just a moment.